Okay, so we've had the first one, free seating, don't touch the table settings. Nothing on the tables. If you've got coffee, somebody's got a Coke there. I think it's, anyway, could you take it off the table, Graham? Thank you. Please, nothing at all on the tables. After the argument, we're going to clear the room. I think we fixed the, okay, it's good. Then we're going to all go over to the park for our traditional mass photograph. And once the two final teams, both the oralists and their support, will be in the front row with the arbitrators. And everybody else will crowd in and we'll have a great photograph. Not the park. Oh, it's just outside. It's not. You'll be led there. Don't worry. It's near the park. Okay. When you're leaving, please take everything with you, because if you don't, it will be cleared off, and then you'll have to try and find it later on. So there will be nothing in the room when it's cleared. And for re-entry, I think you all know you have to have your ticket, and if you don't have your ticket, you will not be able to get in. If there's a problem, you'll just be stopped at the door. So please make sure that you've got your ticket with you. So I think we're about ready to invite our tribunal to take their places. They said they'd be here.
You sit down. Let's have a look. I want to make a note of this.
Have the mics been tested?
Yes. Hello.
Yes. Just say hi.
Hello. Hi.
Okay.
Is it on?
I want to know how close you have to be to.
Is it on?
Okay.
Hello. Oh, good.
Okay. Now lean back as if you were just speaking normally, and now speak, and we'll see if it works.
All right. Testing.
No, you
Not
have to be closer. So,
Okay,
the
so-
mic will have to be closer. So remember that when you're speaking. You too?
Hello, 1, 2, 3.
Like this.
Just be aware that you are being live streamed. You be close to the mic. Okay. Good. I think we're ready to go.
Right.
Okay. Good morning and welcome to the 21st edition of the Vis East Commercial International Arbitration Moot. This morning's case is a dispute between Sensor X PLC of Mediterraneo and Visionic Limited of Equatoriana. And we are here in Danubia this morning to listen to the representative for the claimant, which is the National Law School of India in Jodhpur, and the respondent, Charles University of Prague, Czech Republic. Our esteemed panel, we have on the right, Juan Pablo Argentato, who is the managing counsel of the ICC Court of Arbitration in Paris. On my left, we have Ms. Helen Shi, who is a partner with Fangda and Partners and a vice president of the ICC Court of Arbitration. And in the chair, we have Mr. Neil Kaplan, SC, who is an international arbitrator who really needs no introduction to us here in Hong Kong after his 40 years as a judge and arbitrator, the godfather of arbitration in Hong Kong. Mr. President, I give you the floor.
Thank you. Good morning, ladies and gentlemen. Welcome to the hearing in ICC case number MOOT 100/MN. I think you know who we are. So would you just like to introduce your teams and so we can get the pronunciation of your names right?
Yes. A very good morning, members of the Tribunal. My name is Samiksha Lohia, together with my co-counsel, who I believe I will let to introduce herself. We represent Claimant, Censor X PLC. We represent National Law University, Jodhpur. And I will be addressing the procedural issues today.
Thank you.
Good morning, everyone. My name is Kavya Gupta, and as she said, we'll be representing National Law University, Jodhpur on behalf of the claimant, Censor X PLC. I'll be addressing the substantive part on behalf of the claimant.
Thank you very much. Yes.
Thank you. My name is Simon Puchi, and together with my co-counsel...
Slow down. Say it again.
It's Simon Puchi.
How do you spell? Say it again, the last name?
Puchi.
Puhi.
Puchi, or Puki. It's all right, as you wish.
Okay.
And I'm here together with my co-counsel, Yasmina Pustayova, and we today represent Respondent, Visionik Limited. I'll address the procedure of the case, while my co-counsel will address the merits.
Thank you very much. Right. Have you agreed any sort of timing?
Yes, Mr. Presiding Arbitrator, we have agreed as to the time allocation. It will be 14 minutes per submission and 1 minute for rebuttal and for rebuttal.
Right.
You have
Right. Thank you very much. So, Claimant, would you like to start?
Yes, Mr. Presiding Arbitrator. A very good morning, Mr. Presiding Arbitrator and members of the Tribunal. My name is Samiksha Lohia, and to my right is my co-counsel, Ms. Kavya Gupta. Together, we represent Claimant, Censor X PLC. Members of the Tribunal, there was a contract, there was an amount owed, and it wasn't paid not once but twice. In light of this, there arise two interconnected claims. Respondent's objection to the inclusion of the new claim will not only cause substantial prejudice to both parties, but will also impede the procedural efficiency of this arbitration. Over the course of the next 14 minutes, I put forth two broad submissions. First, the new claim can and should be added to the present arbitration, and second, in the alternative, both the proceedings must be consolidated. With regard to my first submission, that is, the new claim can and should be added, I make 2 points. First, the relevant arbitration agreement allows for such addition, and second, that the requirements under the terms of reference are fulfilled.
Which arbitration agreement are you talking about?
Mr. Presiding Arbitrator, this brings me to my first point, that the relevant arbitration agreement in the present instance is the one mentioned under Article 41 of the Framework Agreement, titled Dispute Resolution, read with Clause 7 of Purchase Order 9601, which I will be referring to as the first purchase order. In the present instance, if I may direct your attention to page 11 of the record. I hope you are with me.
Yeah?
On page 11, we have Article 41, Clause 2, the last two lines of which, and allow me to quote, states that the framework agreement encompasses all possible disputes arising in connection with the present arbitration agreement and the contracts concluded thereunder. Contracts concluded thereunder. Members of the tribunal, what do these words indicate? They mean the purchase orders. If we move to 2 pages down the line, at Purchase Order 9601, at the very top of the page, we have the recital, which states that this purchase order is in line with the framework agreement. Therefore, the arbitration agreement provided for in Clause 7 of this purchase order is in line with the framework agreement. It has been concluded under the framework agreement itself. Moreover, Article 9 of the ICC rules, read with Article 6, Clause 4 of the ICC rules, states that claims under multiple contracts can be heard together should the parties consent to such addition, and should the arbitration agreements be compatible. In the present instance, members of the tribunal, owing to the inclusion of the words contracts concluded thereunder, it is a logical conclusion that the parties have agreed to such addition.
Can you just help us on this? If there's an arbitration agreement in the framework agreement, which you rely upon, what were the parties doing agreeing an arbitration agreement in the purchase orders as well?
Mr. Presiding Arbitrator, the arbitration agreement in the framework agreement is a broad form arbitration agreement and encompasses all possible disputes from the purchase orders. Moreover, when the parties intended, the intention of the parties to include a dispute resolution clause in the purchase orders was merely to showcase their intent to submit any and all disputes to arbitration. There is nothing in the purchase orders that contradicts the framework agreement in any regard. Moreover, coming back to my submissions, the two arbitration agreements, that is the one under the first purchase order and the one under the second purchase order, which you can find on page 13 and page 48 of the record, both of these are compatible, therefore allowing for such addition. The respondent may point out two differences in these arbitration agreements. However, it is our submission that both these differences are reconcilable. The first difference they may point out is with respect to the number of arbitrators members. It is a fact that the first purchase order states that a panel of 3 arbitrators, specifically this very panel of 3 arbitrators, will adjudicate the dispute. To the contrary, on the second purchase order, it is stated that a panel of 1 or more arbitrators will adjudicate the dispute. This is not any incompatibility at all, members of the tribunal, since the wording of 1 or more leaves open to the ICC court to appoint a panel of 3 arbitrators, first. Second, a sole arbitrator will not be appointed in the second instance for 2 reasons. The threshold for the appointment of a sole arbitrator, as per the ICC Secretariat's guide, is when we look at the amount in dispute, as well as the factual complexity of said dispute. In the present instance, the amount in dispute is $12 million for the second claim. The ICC Secretariat guide again sets out a threshold for said amount. It is $5 million. Therefore, we exceed the amount in dispute and a sole arbitrator will not be appointed. With respect to factual complexity, it is our submission that since the existing claim and the new claim bear not only similar but also common questions of law and fact, it will be this very panel of 3 who must adjudicate the second dispute. Proceeding to the second alleged difference and incompatibility that the respondent may point out, that is with respect to the rules on emergency arbitration. This is not any incompatibility at all, members of the tribunal, since emergency arbitration can only be invoked when the file has not been transmitted to the tribunal. In the first claim, the file has already been transmitted. Therefore, emergency arbitration cannot be invoked. In the second claim, it excludes the rules on emergency arbitration, and therefore this is not any incompatibility at all. Proceeding to the second point of my submission, that the requirements under the terms of reference have been fulfilled. If I may invite your attention to page 55 of the record. This contains an excerpt of the issues to be determined paragraphs of the terms of reference. At this very page, I hope you are with me. At this very page, we have clause 85, which allows for addition in 2 circumstances. Let's read this clause together. This third line states that subject to any new claims as per Article 23, Clause 4, which is the first requirement, and second, which will be authorized if they result in noticeable savings of cost and time, which is the second requirement. Let's deal with these one by one. With respect to the requirement under Article 23, Clause 4 of the ICC rules, this provision states that new claims may be added when we take into account the nature of the two claims and the stage of the arbitration proceedings. Members of the tribunal, the threshold for the nature of the two claims, as was held by a similarly situated ICC tribunal in the case of 16010, it was stated that the nature of the two claims implies the similarity and the proximity to the existing claim. In the present instance, the two claims bear similar questions of fact or law. With respect to the two claims, allow me to paint you a picture. Both the purchase orders are concluded under the framework agreement. Both claims stem from each purchase order. Both the claims deals with the non-payment of the respondent. Both the claims also deal with the intrinsic underlying question of fact, that is, whether emails are a valid form of amendment to Article 40 of the framework agreement. Both claims also deal with the causes, effects, and implications of the cyber attack. Therefore, there arise similar and proximate claims to each other. Proceeding to the second requirement under Article 23, Clause 4, that is the stage of the arbitration proceedings. Again, the standard for the stage is that we must look at the stage of the current proceedings and whether they will be disrupted should the new claim be added. It is our submission that since there's only been one round of written submissions that have happened, the new claim can be added since this arbitration will not be disrupted in any manner. Moreover, with respect to the second requirement under the terms of reference, that is noticeable savings of cost and time, members of the tribunal, while the word noticeable has not been defined in the ICC rules, we must interpret it in line of Article 22, Clause 1, which states that all arbitrations must take place in an expeditious and a cost-effective manner. In the present instance, since there are two claims bearing similar questions of fact that are also the common underlying causes of action for both, if there are two parallel arbitration proceedings, members of the tribunal, what's going to happen is that both the tribunals will have to sit through the same questions twice. They may come to conflicting decisions, which may lead to the award being set aside, as was done in the case of W versus AW. Moreover, if the tribunal has no further questions, I would like to move on to the second broad submission before this tribunal today.
I have a question, counsel. Going back to the issue of the number of arbitrators in the second purchase orders, you told us that it is not incompatible with the other arbitration agreements that you're relying.
Yes.
Framework agreement and purchase order number 1. Who will fix the number of arbitrators in the second purchase order? Do we need a court decision, or it's already determined?
Mr. Arbitrator, to fix the number of arbitrators, it is the ICC court who will come in and fix the number. The parties, it is our submission that this very panel of 3 arbitrators must add the new claim, thereby adjudicating the second dispute. With regard to my second broad submission before this tribunal today, the new claim, should the claimant be forced to raise it in a separate arbitration proceeding, both these proceedings must be consolidated. In this regard, we have 2 submissions. First, that this tribunal can authorize the consolidation of the 2 proceedings. And second, that the subjective requirements under Article 10 of the ICC rules, along with Article 41, Clause 5 of the Framework Agreement, have been met. Members of the tribunal, if I may direct your attention to page 12 of the record. This is again the framework agreement concluded between the parties. I hope you are with me.
Yep.
On page 12, members of the tribunal, we have the provision on consolidation, which states in its second last line that the arbitral tribunal of the first arbitration proceeding has the power to consolidate. the parties, by virtue of their party autonomy, have provided this tribunal with the power to consolidate the two proceedings. This has also been done under the ICC case of 13876, that is Sonera versus Kukurova, and was done without any confirmation by the court. Therefore, Article 10 is not a mandatory rule under ICC rules, and in fact, the parties can derogate from it and allot the power of consolidation to this tribunal, which they have. Lastly, with respect to the second point, that is the subjective requirements under Article 10 and Article 41, Clause 5, as I have demonstrated, there exist three integral common questions of fact which may lead to a possibility of conflicting awards should there be parallel proceedings. Moreover, Article 10 is a disjunctive provision, members of the tribunal. That means only one of its three subparagraphs have to be fulfilled. In any case, we have fulfilled all three of its subparagraphs. The parties have agreed to consolidation. The arbitration agreements are compatible. Therefore, in this case, we conclude to state that the new claim must be added to the present arbitration, and in any case, both the proceedings must be consolidated. Thank you.
Do you have any questions?
Claimant's counsel, what are the basis for bringing this arbitration case? We noticed that you brought this arbitration case previously based on arbitration agreement in the purchasing order 1, and now you are adding another claim. So what's the basis? What's the legal, what's the arbitration clause or clauses you are relying upon?
Madam Arbitrator, I see that my time has elapsed. To answer your question, may I please seek an extension of 30 seconds? Thank you. Madam Arbitrator, the relevant arbitration agreements in this instance are the ones under Article 41 of the Framework Agreement, read with Clause 7 of Purchase Order 9601. This is due to two reasons. First, the parties very consent for these two agreements to be the relevant arbitration agreements, as was stated in their terms of reference, as well as the request for arbitration. And second, as per Article 7, Clause 6 of the Danubian Arbitration Law, which is a verbatim adoption of the UNCITRAL model law, parties can incorporate an arbitration clause by reference to another contract, which they have done via the recitals in the purchase orders. Thank you.
Any more questions? Thank you very much. Yes, Ms. Gupta. Oh, sorry. This way. Yep.
Thank you very much, Mr. Presiding Arbitrator, members of the Tribunal. Claimant tried to portray the two claims as forming a coherent structure where everything connects perfectly, as if this was a game of Tetris. However, Claimant's attempt to add a new claim or consolidate the two proceedings should be rejected, as the two claims are far from being interconnected. In fact, the initial claim arose after Claimant failed to make proper cybersecurity measures, which also impacted Respondent in its payment for S4 sensors under the Purchase Order 9601. This will also be addressed by my co-counsel in just a few moments. On the other hand, the new claim arose after Claimant sent defective goods, defective LiDAR sensors, under another Purchase Order A15604. Additionally, the late bringing of the new claim is a result of Claimant's internal problems, who now refuses to assume responsibility for its actions. Therefore, on that basis, Respondent will have two submissions. First, that this tribunal cannot and should not allow the authorization of the new claim to the proceedings. And secondly, when the new claim is raised separately, that this tribunal cannot and should not consolidate the two proceedings.
Well, doesn't that lead to a risk of inconsistent decisions?
No, Mr. Presiding Arbitrator. This is because there is a lack of sufficient overlap as to the questions of law or fact as contrary to the claimant's assertions. I will get back to this point in just a few moments, but first I would like to establish the jurisdiction of this tribunal to follow the structure set out by the opposing party. Firstly, Claimant relied on the framework agreements, arbitration agreements, as forming this tribunal's jurisdiction, together with the arbitration clause in the purchase order for S4 sensors. However, that is not the case. It is true that Claimant, in his request for arbitration, indicated that the framework agreement is an additional relevant arbitration clause. Still, Claimant relied heavily only on the S4 purchase order arbitration clause when it indicated what clause would form the arbitral tribunal's jurisdiction. It only referred to the framework agreements clause as other additional clause as to support the initial will to arbitrate. However, this tribunal's jurisdiction, because it was also constituted under the purchase order for S4 sensor clause, is solely the clause contained in that one purchase order. It was similarly decided in a very recent Hong Kong case decided by the Hong Kong High Court within the case number 513, where the court decided that a tribunal, when it assumed jurisdiction over two contracts, a loan agreement and a promissory note, which contained slightly different arbitration agreements, did wrongly in assuming its jurisdiction over those two clauses. That's because Claimant in those proceedings indicated as the only or the primary clause, the one in the loan agreement, and only referred to the second arbitration agreement as the other relevant agreement. Then the court decided that that tribunal's jurisdiction is limited to the primary arbitration agreement, which was invoked by the Claimant as the main one. And we asked this tribunal to apply the same standard here, to rule that this tribunal's jurisdiction is limited to the arbitration clause for the S4 sensors and not the framework agreement. Additionally, the opposing party invoked correctly Article 6, Paragraph 4.2 of ICC rules, which, together with Article 9 of ICC rules, state that the tribunal may assume jurisdiction over multiple contracts even if they contain multiple arbitration agreements. But it is so only if two conditions are fulfilled. First, the arbitration agreements are compatible, and second, the parties have consented to such a multi-contract arbitration. To the first point, the opposing party directed you to page 13 of the case file, which is the purchase order for S4 sensors, and it contains its specific arbitration agreement. Then, on page 48 of the case file, we see the purchase order for LiDAR sensors relevant for the new claim, which again contains its own specific arbitration clause. Still, today Respondent is not contesting that these arbitration agreements are compatible. Still, however, they contain two differences as to the number of arbitrators and as to the exclusion of the emergency arbitration. And it is Respondent's submission that by simply having two distinct arbitration agreements, even if compatible, this tribunal should not assume jurisdiction over both of these. And that is because it relates to the second requirement of Article 6, that by including specific arbitration clauses in the purchase orders, the parties had the intention to arbitrate the two claims stemming from those purchase orders in separate proceedings.
But on the other hand, you could say, couldn't you, that because there was no arbitration agreement in the framework agreement, that they intended everything to be covered by the framework agreement? Why is that not a good submission?
Mr. Presiding Arbitrator, it is Respondent's submission that by including later on specific arbitration clauses in the purchase orders, the parties essentially displaced the previous arbitration clause in the framework agreement. Hence, and as I stated before, the only relevant clause for this tribunal taken into consideration is the one contained in the first purchase order for S4 sensors. And that clause does not cover the disputes from another arbitration agreement in the other purchase order. And the compatibility is not of issue because, as was also decided in, for instance, ICC case number 7893, where a tribunal refused to assume jurisdiction over related contracts, even if they contain multiple compatible or even identical arbitration agreements. And it refused to assume jurisdiction over both of these contracts precisely because they contained each individual arbitration agreement. And it showed that the parties had the intention to arbitrate the two claims stemming from those two contracts in separate forums.
So what do you say is the most efficient way of disposing of this issue?
the most efficient way for this tribunal to take is to solely rely on the arbitration clause for the S4 censors and firstly resolve the dispute regarding the S4 censors, and to leave the dispute arising from the other purchase order to a whole distinct tribunal.
If I may, counsel, but the ICC arbitration rules expressly provide that it's possible to arbitrate claims under multiple contracts in one arbitration.
This is true, Mr. Arbitrator. However, this tribunal should rather follow the intention of the parties. And the intent of the parties, by including specific arbitration agreements in the purchase orders, was clearly to leave the disputes to separate tribunals. Because why else would the parties include specific arbitration agreements in those purchase orders? They could have easily only referred to the previous framework agreements clause as to avoid any complications, but rather the parties intentionally chose specific clauses as to argue for separate tribunals.
And if I may, a follow-up question. What do you make of the submission of opposing counsel referring to the first part of the purchase orders, which refer to the framework agreement?
Yes, it is true that in both purchase orders there is a reference to the framework agreement's provisions to be governing the purchase orders. However, it is also stated in those preambles to the purchase orders that the framework agreement would govern the purchase orders unless agreed otherwise. And specifically in our paragraph 7 of both of these purchase orders, the parties have agreed otherwise as to the dispute resolution mechanisms to be put in place for claims stemming from these purchase orders. Now, this brings me to the second point, which was also invoked by the opposing party. It is that even if this tribunal were to assume jurisdiction over two contracts, it should nevertheless refuse the authorization of the new claim as the relevant considerations under Article 23, Paragraph 4 of ICC rules were not met. This provision grants the tribunal the power to add new claims after considering the nature of the new claim, the stage of arbitration, and other relevant circumstances to the nature of the claim. And as opposed to claimant's assertions, there is a lack of common questions of facts or law in regards to the two claims. To the factual side of things, it is true that both claims arise from the two purchase orders, which are both governed by the framework agreement. However, these two were still distinct purchase orders for different goods. One was for the S4 sensors and one was for the LiDAR sensors. And this has other implications as well, because, for instance, in regards to the LiDAR transaction, there was a different personnel responsible there. On the claimant side, for the S4 transaction, it was Ms. Audi. However, for the LiDAR transaction, it was Ms. Bejatran and Ms. Durand. Hence, it is not true that combining these two claims will lead to no additional submissions of evidence, because there is a lack of factual overlap between the two claims in this regard. And to the questions of law, the opposing party invoked Article 40 of the Framework Agreement as a potential connecting legal question. Article 40 of the Framework Agreement indicates that any amendments to the FA need to be in written and signed form. However, the two instances of amendments in the new and the initial claim were different in the circumstances surrounding them. In the initial claim, the alleged amendment is the change of the banking details through an email, through a written email. However, as to the new claim, the amendment of question is the oral amendment as to the change of form for notice of defects. Hence, it is not true that if two tribunals were to decide this question of Article 40 in two separate proceedings, they would come to different conclusions. It is simply that these two instances of amendments differed in the circumstances, and therefore there is no connecting legal question or sufficient connection there. Coming to the second point, which is the noticeable savings of cost and time as a requirement, additional requirement as per terms of reference. Now, the opposing party stated that adding a new claim will result in a savings of cost and time. However, the opposite is true. Because as I stated before, the two claims lack a sufficient factual and legal overlap between them. Adding the new claim to the proceeding would only prolong the proper resolution of the initial claim in this regard. And this has direct implications on the costs incurred by the parties as well. That's because, for instance, on the amount of the initial claim, there is a 4% interest rate placed there on the amount of 38.4 million US dollars. This could mean that if the resolution of the initial claim is prolonged, there might be additional accumulation of interest, which would be 100,000 US dollars monthly alone, potentially incurred by respondent. Therefore, simply stating that the addition of the new claim will result in savings of cost and time is unfounded.
Excuse me, counsel, but the proceedings have been bifurcated to address these issues separately.
That is true, Mr. Arbitrator. However, what the opposing party is stating that since there is an overlap between the two claims, there is only the need for a single submission of evidence, for instance. And since there would be a single submission of evidence, this submission would need to be done in the very first part of the arbitration. Hence, it would in fact prolong the resolution of the initial claim, having effect also on the costs of arbitration. Now, moving to the second submission, that is when the new claim is raised separately, that this tribunal cannot and should not consolidate the two claims. And contrary to the opposing party, this tribunal does not have the authority to authorize consolidation of the claims. In fact, the parties have included a consolidation provision granting this tribunal the power to consolidate. However, this clashes with Article 10 of the ICC rules, which states that it is the ICC court that allows for consolidation. And it is respondent submission that this is a non-derogable provision. And that is because, similarly to, for instance, the scrutiny of the awards, which is also labeled a mandatory provision, the consolidation provision and consolidation by an ICC court is to be deemed as mandatory because it relates to core and distinguishable features of the ICC court and the ICC arbitration, and it ensures the quality of the process. It was also decided, for instance, in an ICC case where the two parties have also concluded a similar consolidation provision, granting the power of consolidation to the tribunal. Nevertheless, this was refused by the ICC court, and the number for that case is the 18724. Hence, this tribunal cannot consolidate the proceedings. And that would conclude my submission. Thank you.
Respondents' counsel, we understand your argument, but would you agree that the framework agreement, Article 41, dispute resolution, is arbitration clause signed between the parties and the parties' agreement? Do you agree on that?
Yes, the framework agreement.
And do you also agree that tribunal can consider the agreement of the parties in this framework agreement in deciding this procedure issue?
When it comes to consolidation, yes, even if the tribunal were to assume that the consolidation provision is valid, there are still conditions to be met in regards to the consolidation, mainly the condition of common questions of law or fact. And as I stated before, there is a lack of sufficient connection as to the questions of law or fact between the two claims, and therefore, this tribunal cannot allow for consolidation.
Thank you. Thank you.
If I may,
Please.
Mr. President, if you could clarify, counsel, what's the legal basis of Article 10 being a mandatory provision under the rules? And do you consider that all provisions of the rules are non-derogable?
Mr. Arbitrator, there is nowhere in the ICC rules itself stated which provisions are and which are not mandatory. It is only according to the long-standing practice of the ICC court that we can analyze which provisions are to be deemed as mandatory. As I mentioned, for instance, in the case of Samsung Electronics with Comonda AG, it was decided that the scrutiny of the awards is a mandatory provision or can be deemed as one, because it did relate to a core and distinguishable feature of ICC arbitration, without which the ICC court would be deprived of the proper administrative functions. And the same would apply to the consolidation. That's our argument.
Okay, all right, thank you very much. So now we do go to the merits.
Rebuttal.
Oh, you've got to rebut. Right. Off you go.
Members of the tribunal, I have 2 points in rebuttal. First, to a question raised by Mr. Arbitrator to opposing counsel, he stated that since there will be bifurcation of proceedings, there will be a single taking of evidence. We completely agree with this, members of the tribunal, but we must see that noticeable savings of cost and time have to not be read in absolute terms, but rather in relative terms. If there are parallel proceedings, members of the tribunal, not only will there be both tribunals dealing with the same questions of fact over and over again, there will also have to be evidence taking twice, and in fact, it may lead to enforcement concerns under Article 5 of the New York Convention. Moreover, secondly, with respect to the consolidation of argument of my opposing counsel, he himself had stated that Article 10 is not a mandatory rule of the ICC rules. Therefore, the parties have vested with this tribunal the power to consolidate, and hence consolidation can be done. Thank you.
Thank you.
Members of the tribunal, the opposing party admitted that the addition of the new claim will lead to additional evidence and the prolongation of the initial claim, which, as I stated before, it will lead to additional potential costs incurred by the parties. And this is in line with what was also stated, that the noticeable savings of costs and time does need to be interpreted generally, and all potential costs and time need to be evaluated. Therefore, the argument still stands. Thank you.
Thank you very much.
Sorry if I may,
Yep, thank you.
Mr. President. Could you reply to the second point?
Consolidation, Article 10 not being a mandatory rule.
We are disputing that, members of the tribunal. We are stating that the Article 10 is a mandatory provision, just as scrutiny of the awards.
Okay. Right.
Thank you, Mr. Presiding Arbitrator, members of the tribunal. The opposing counsel on procedure stated, and I quote, that respondent has not paid, not once, but twice, end of quote. Now, claimant submits that this non-performance was caused by claimant, not once, but twice. But to provide some context, in March 2022, respondent has received an email with a request for bank details change. However, this preceded a cyber attack on claimant. The cyber attack was caused by claimant's employee, Ms. Audi, who clicked on a non-work related phishing email, downloaded malware, and enabled a cyber attack. The cybercriminal accessed claimant's systems, including sensitive information about claimant and respondent. The cybercriminal used this sensitive information to create the fraudulent request for bank details change, which I will refer to as the spoofing email. Since claimant kept quiet about the cyber attack, respondent authorized both payments for the order for S4 sensors to the cybercriminal's bank account.
How much was it?
It was $38,400,000.
Quite a lot of money.
It is, Mr. Arbitrator, but it is our submission that it has to be bore by the claimant, because claimant was the reason why respondent had sent this money to the cybercriminal's bank account.
Is that right? I mean, why did you phone up and ask for details, confirmation?
Mr. Presiding Arbitrator, it is our submission that, first, if we had been informed by claimant about the cyber attack, we would have taken more preventive measures. However, in the light of not having this information, the respondent was reasonable in relying on this spoofing email, which I will address also in both of my submissions.
You'll take us to the spoofing email, won't you?
I will,
Good.
Mr. Presiding Arbitrator. But before that, let me first establish what respondent will submit in this proceedings. Respondent does not contest that it did not fulfill its contractual obligation. Rather, it relies on the exemptions in the CASG. And on that basis, respondent has two submissions. First, respondent can invoke Article 80 of the CASG. And second, respondent can invoke Article 77 of the CASG to at least reduce its payment obligation. Now to the first submission. The Article 80 exempts a party from non-performance if the non-performance was caused by the other party, and therefore has two conditions. First, there's an act or omission by one party, and second, there's causal link.
Is the act or omission, does that have to be a contractual breach of some sort?
Mr. Presiding Arbitrator, as to the act, it does not have to be any contractual breach. And as to the omission, for an omission, there does not need to be a duty formally expressed in the contract or the law. It is enough that the party violates its duty to cooperate that is directly incorporated in Article 80 with interpretation of the Article 7, the good faith, paragraph 1.
So your breach is their failure to tell you about the cyber attack.
Precisely, Mr. Presiding Arbitrator. But before that, I would quickly elaborate on the act of claimant. It was the act of Ms. Audie, claimant's employee, who falls in claimant's sphere of risk, who clicked on the phishing email, the link included therein, and downloaded the malware, enabling the whole cyber attack in the first place. But it is also the omission, as I stated before, the omission to inform. Now, the Article 80, when interpreted as provided in Article 7, paragraph 1, with the good faith principle, has been held to encompass cases with insufficient cooperation between the parties. For example, in the Steele's Channels case decided by a tribunal under CETAC in arbitration, there was a problem with the goods being held at the customs. And while it was held that it was the buyer who was responsible to deal with the customs, the seller was held to cause non-performance by not cooperating, namely by not providing sufficient information about previous problems with the customs before, and that was also despite being any under formal information under the contract to do so. Similar result was also adopted, for example, in the machinery case decided by the German Supreme Court. Now, the extent...
Excuse me, counsel. Why, you mentioned the two cases. One is a German court case and one is arbitration case, CETAC arbitration case. Why do you think the tribunal should take reference of these two cases?
Madam Arbitrator, we do not submit that these are binding on this tribunal. However, they express the interpretation of the Article 80, which has been broad in the past and has been interpreted with regards to the interpretative tool of Article 7.1, the good faith.
Thank you.
Now, the extent of the duty to cooperate in each individual case is determined by using reasonableness. And we submit that in this case, it was reasonable to inform respondent about this cyber attack. It is stated, for example, from the objective standpoint, in the soft law instruments such as the ISO standard 27010 or the OECD guidelines, that it is reasonable to report about data breaches to the business partners. But also the circumstances of our present case indicate the reasonableness. That would be first, because there is information asymmetry between the parties. And also, because the loss was disproportional to the measures that could have been taken to prevent it.
So if they told you about it, what would you have done differently?
Mr. Presiding Arbitrator, if respondent had known, it would have presumably examined the email with much more carefulness and presumably also confirmed this email with claimant. In fact, respondent did try to confirm this email with claimant's employee, which, however, due to claimant's own internal problems, was inaccessible. However, as a second response to your question, we submit that since this is a hypothetical scenario, we must go through the doctrine and the standards in the interpretation of the Article 80. And in our opinion, that would be the causal link standard. But before that, let me shortly conclude that there was relevant act and omission of claimant. But now to the second condition, the causal link, which can help us understand whether respondent was expected or wasn't expected to overcome this risk. Now, under Article 80, causation is established if one party creates a risk that the other is not expected to overcome. In our case, we submit that respondent was not expected to overcome this risk posed by the email. In determining what the party is expected to overcome, reasonableness is used as a general principle of the CASG, and it was similarly held in a Mass Van den Brink v. SAS Industrial Trading case, where court has also used the Article 8 standard of the reasonable person to assess whether the buyer was reasonable in relying on the spoofing email. Now, if I may take you to the page 16 of the spoofing email, as I promised.
Yes, we have it, thank you.
Yes, this is the spoofing email sent to respondent. Now, Even at the first sight, it looks as previous email communication from Claimant, including the logo and the names of the employees. But it is really the contents of this email that made it reasonable to rely on. It includes multiple sensitive information, for example, the number of the purchase orders or the due date for delivery of the sensors. And in the context of Claimant presenting itself as having top-notch cybersecurity and involving the most prominent cybersecurity firm in the country, Respondent was confident that Claimant will protect this sensitive information and that it was only Claimant who could access this, and hence relied on this information. Now, Respondent concedes that there are some discrepancies in the email, of course. However, under Article 80, the performance does not need to be made impossible for a causal link to exist, as was held, for example, in the propane gas case, also decided by the Tribunal under CETAC arbitration. And Respondent does not submit, therefore, that it was impossible for Mr. Royce, the reader of this email, to discover it as fraudulent. Rather, that the level of sophistication was high enough and the discrepancies were too minor as to outweigh the overall authentic-looking email.
What are the discrepancies?
Mr. Arbitrator, the discrepancies would include, maybe will be raised by the opposing counsel, for example, the typos or the differing email address, including a one-letter difference between M and N. And Respondent to that submits that these are too minor as to outweigh the authenticity. In fact, they have, yeah.
Just a minute. So the heading says telsa.ord at semsor, right, with an M, is that right?
Yes,
And that's wrong.
yes,
But if you go down to the bottom, it's got the right address.
yes, it does.
So there's a discrepancy on the face of the document.
Yes, Mr. Arbitrator.
Isn't that significant to you when you read that?
Mr. Presiding Arbitrator, in our opinion, it is not significant as to point any red flags in the light of the sensitive information. In fact, the same exact typo, including M and N difference in the name of Claimant's company, was made in the very preamble of the framing agreement. Actually, typos, including typos in the email domain, have been included in previous communications between the parties and even in Claimant's very own request for arbitration, where also a mistake in the domain name is made.
Isn't it common knowledge that hackers rely upon these very minor changes to information like email addresses? And there you've got a document in front of you where there's a conflict on the face of the document, and you didn't make a phone call.
Mr. Presiding Arbitrator, it is our submission that without knowing that there was any problem with Claimant's cybersecurity or any cyber attack having occurred, it was reasonable to not notice these mistakes as they have been overlooked in the past. But what could have shifted the odds would be precisely the information from Claimant. That is our submission. And therefore, we submit that there was no causal link, there was causal link established, excuse me.
If I may, counsel, apologies. You refer to minor discrepancies in the spoofing email. You consider that this transfer of 20 million was minor as well? That's why you did not verify for your company?
Mr. Arbitrator, to answer that question twofold. Firstly, we submit that, yes, it was a reasonable email that was explained. However, even as concerning the volume of this transaction, for a Respondent being a much bigger company, a multi-billion-dollar company, this might have been an ordinary transaction. However, for Claimant, much smaller company, it was a very big transaction. And therefore, if we want to take the volume of the transaction into the account, it should rather argue for Respondent to state that Claimant was supposed to take more care and inform Respondent about cyber attack concerning such a big transaction was in place. Which would conclude my first submission that Article 80 can exempt Respondent as there was act and omission of Claimant and a causal link. But now to the second submission, that even if the Tribunal does not exempt Respondent on the grounds of Article 80, it should at least reduce its performance under Article 77. This article states that a party who relies on the breach of contract must take reasonable measures to mitigate damages. And this article is meant to prevent a party from passively sitting back. Now, it is true that it only explicitly mentions damages, but it has been, in the past, applied also through its underlying principles, the duty to mitigate loss. For example, in the German Clay case decided by the Federal Court of Justice of Germany. Now, Claimant had multiple opportunities to mitigate loss. Not only could it inform Respondent right after the cyber attack, it could also notice the missing payment, which it would if it had not been for its internal problems and staff shortages. If Claimant had noticed the first missing payment, Respondent would not send the second one, but even the funds from the first payment could be mitigated. That is because, in the context of cyber fraud, if parties act quickly and notify their bank, the bank can still freeze the account of the cyber criminal, retrieving the funds. And therefore, had Claimant noticed the missing payment, majority of loss could be mitigated. And this mitigatable loss should be attributed to Claimant and should at least reduce Respondent's performance. Members of the Tribunal, to conclude, Claimant not only caused this non-performance, it also kept Respondent in the dark and created unnecessary risk that Respondent cannot be asked to bear. And on that basis, we ask this Tribunal to exempt Respondent under Article 80 or subsidiarily under 77 CASG. Thank you.
Thank you. Okay. Anything else? Yep.
Counsel, I do have a question. I noticed that in the framework agreement, Article 7, payments, there are actually two accounts for the bank transfer. I'm not sure whether in the problems has anything mentioned the past dealing of the parties in making the payment, whether the parties use exchange of email or phone calls to confirm the bank account.
Madam Arbitrator, it is true that the bank details change is subject to Article 40 amendments. However, and which requires that the amendment is in written and signed form. We do not contest that the email does not fulfill this requirement. However, we are not submitting that this Respondent's payment was performance, and therefore, we only need to prove that it was reasonable to rely on this email. Now, in the past, the parties have amended the framing agreement informally 2 times, which made it reasonable to rely on this instance. If that answers the question.
Okay.
Right?
Okay.
Right. Ms. Gupta.
A very good morning, honorable members of the Tribunal and the counsels for Respondent. My name is Kavya Gupta, and I will be addressing the merits of the case on behalf of the claimant, Sensorex PLC. Members of the Tribunal, has the Respondent made the payment? We agree it has. However, has that payment been received in the claimant's bank account? The answer is no. Claimant has not sent the phishing email. Claimant has not amended the framework agreement. And yet, the Respondent contended that they should not be made liable to bear the burden of a second payment. In line with this, in the course of the next 14 minutes, I make 2 broad submissions. First, claimant is entitled to receive complete payment under Purchase Order 9601. And second, the Respondent cannot sidestep this liability by using Article 80 or Article 77 of the CISG. Beginning with my first submission, members of the Tribunal, Article 53 of the CISG mandates the buyer to deposit the purchase price in the designated bank account of the seller as per the terms of the contract. Now, as also pointed out by Madam Arbitrator, if the Tribunal please may follow me to page 10 of the record, which contains the framework agreement between the parties. Members, Article 7 of the framework agreement titled Payments clearly states 2 bank accounts to which all the payments have to be made. One is the Automotive Bank in Mediterraneo, and second is the First Bank of Mediterraneo. Now, it is undisputed that the Respondent has paid to an unauthorized bank account, the First Bank of Danubia, and they still claim that their contract has been fulfilled. Now, and they also submit that relying on the phishing email was reasonable on their part. If I may direct you to page 16 of the record, which contains the phishing email. I hope the tribunal's with me.
Yep.
Members, this email is overflowing with discrepancies, which the counsel for respondent also concedes to. However, if I may just highlight it for the benefit of the tribunal. First, beginning at the top of the page in bold, the domain name is incorrect as it states SemSerX instead of SensorX. Now, we agree that a same mistake has been made in the preamble of the framework agreement where it does state SemSerX. However, the implications of a typographical error in a preamble of a framework agreement or a domain name are extremely different. There, in fact, cannot be any typographical error in the domain name as it would change the sender's address itself. Although, even if we ignore that and move forward with the email, members, in the first paragraph, it states, in the third line, under purchase order number 15605. Members of the tribunal, it is a common fact now, and as has also been stated by my co-counsel, the second claim was under purchase order A15604. This is again a discrepancy highlighted in the email. Moving further, the bank account has been changed to an entirely different country, a different jurisdiction from Mediterranean to Danubia. Now, members, we do agree that it was a familiar bank account between the parties. In the past, one transaction was made between the parties. However, it was a subsidiary that was involved. And further, had the respondent taken reasonable care and attentively reviewed the email, it would have realized that the IBAN number would at least change. Even if we move forward, members, the number of the S4 sensors in the next paragraph is stated as S425889. However, the correct number is S425899. Lastly, members of the tribunal, it is ironic that in the closing of the email, there's a telephone number that has been mentioned. The telephone number is not of Miss Audi, but of their own head of purchasing, Mr. William Toyoda, who in fact read this email. Now, members, it is certainly not reasonable for an account manager of a tier 1 company in the automotive industry to reasonably rely on this email and make a significant transaction of $38.4 million US. However, even if the tribunal still believes that this email should be attributable to our client, we submit that this email dated 28th March does not validly amend Article 7 of the Framework Agreement, as it does not satisfy the written form requirement as per Article 40 of the Framework Agreement. Now, Article 40 of the Framework Agreement states that an amendment to this framework, it can be found on page 11 of the record, if the tribunal's with me.
Yep.
Members, it states no amendment or waiver of any provision of this agreement, including this article, shall be valid unless the same is in writing and signed by both the parties.
But there is evidence that the parties deviated from this clause in other instances, right?
Mr. Presiding Arbitrator, to answer that question, if you please may follow me to page 63 of the record. This is the Procedural Order 2. Paragraph number 12 on this page, members. If we see this, it is explicitly stated that in the past, where parties did agree to a change in the bank account, the same was done, as can be found in the 4th line in this paragraph. The parties had agreed in a signed side letter and not an email. Just the preceding point before this on page number 62, members. Paragraph 11 states, confirmation letters were sent even for deviations in the purchase orders. Moreover, circling back to my submissions, do I sense a question?
Please proceed. Yeah.
Yes. Members of the tribunal, Article 29, Clause 2 of the CISG also states that if a contract contains a provision that mandates a written modification, that contract cannot be altered in any other manner. In the present circumstance, there is only one instance where the parties agreed to a change in the bank account, and the same was done by strictly conforming to the form requirements of Article 40. and therefore we submit that the parties' conduct and the past practice shows that they intend to strictly comply with the requirements under Article 40. Now, even in the one instance that the parties did agree to a deviation from Article 6 of the Framework Agreement, now this can be found on paragraph 11 of the record, paragraph 11 on page 6 of the record, apologies. Members, we see that there was an informal email sent. However, in that circumstance, there was a physical meeting between the lead sales and purchase managers of both the parties, and therefore a mutual consensus was arrived at. The situation there and the situation here are very different. In this case, since there was a position of authority was confirmed between the parties, the situation is strikingly different from the present case. This, in fact, do I sense a question again?
Yeah,
This, in fact, brings me to my second submission, that the respondent cannot sidestep this payment liability by relying on Article 80 of the CISG. As already highlighted by the Counsel for Respondent, Article 80 has two requirements. First, that there should be an act or omission which has to be a duty. And second, that act or omission should cause the non-performance of the contract. Modeled on these two requirements, I make two submissions under this. First, there was no duty on the part of our client to inform the respondent about the cyber attack. And second, the non-disclosure of the cyber attack in any case did not cause the non-payment on the part of the respondent. Addressing the first submission, I shall give 3 points to prove this. First, at the outset, while we do acknowledge that the respondent informed our client about the cyber attack back in 2020, however, they are under an explicit obligation under the Article 34 of the Equatorian Data Protection Act to inform our client about the same. The EDPA, which is a verbatim adoption of the European Union GDPR, is not applicable on the claimant, as it explicitly goes against the public policy of the legislators in Mediterranean, who excluded such an act to not create an additional burden in the company situated there. However, even if we do consider that this act should be applicable to our client, we straightforwardly fall under the exception of the same. Article 34, Clause 3 of the Act states that if the party has taken technical and organizational measures, then the information is not necessary to be informed to the other party. Looking at the present circumstance, members, it is our submission that the claimant took all proactive steps to prevent the cyber attack in the first place. The same can be seen via employee training and technical safeguards. Our client also implemented the new cybersecurity concept, and when we got to know about the first cyber attack back in January 5, Cybersec was employed, which was a leading cybersecurity firm in Mediterranean, who assessed the attack to be of minor relevance. Second, even if we do consider that they informed us, one sole incident cannot amount to past practice under Article 9 of the CISG. As also stated by Professor Schwenzer or Professor Krull, a past practice needs to be repeated and consistent, and a reasonable expectation needs to be created on the part of the other party. Looking at the present circumstance, no such reasonable expectation was created on the part of our client. Second, and more importantly, there exists no legal obligation either under the CISG or under the Danubian Contract Act to inform the other party about the cyber attack. Now, the counsels for respondent did mention that Article 80, under which the underlying principle is the duty to cooperate, our duty to inform is under that article. However, it is our submission that under the duty to cooperate, this duty to inform does not exist. And this is because, as also highlighted by Professor Krull in his commentary, anything that would encompass under this duty to cooperate has to be necessary for the performance of the contract. In the present matter, we submit that had the respondent read the email in a reasonable and a commercially prudent manner, it would have realized that our client did not send it, and it wouldn't have relied on this email to make such a significant transaction. And therefore, under Article 80, such a duty does not arise. Even if we look at Article 5.5.3 of the Danubian Contract Act, which is the verbatim adoption of the Unidroit principles, it states that such duty would only arise if it is reasonably expected on the part of the other party. As already demonstrated, such reasonable expectation does not arise in the present matter. Third, yes.
Now finish your third point.
Third, members of the tribunal, there is also no contractual obligation on the part of our client to inform the respondent about the cyber attack. The framework agreement is silent on such a clause, and the Article 42, Clause 1 of the framework agreement is an entire agreement clause which clearly states that this document contains the entire agreement between the parties. Now, since the framework agreement contains no explicit clause with respect to informing the other party about the cyber attacks, such duty does not arise. I see that my time is going to elapse in the next 30 seconds. If I may just take additional 30 seconds to wrap up my submissions.
Let me just ask you this
Yes.
question. Standing back and looking at what happened here, if the claimant had told the respondent about the cyber attack, and if the respondent had read the email properly, none of this would have happened. So both parties could be said to have perhaps behaved in a way that they shouldn't have done. So if that's the conclusion we come to, who should be liable?
Mr. Presiding Arbitrator, to answer that question, the Counsel for Respondent relied on Article 77 for reduction of payment. However, it is our submission that even that provision is not applicable to the present matter, and that is because Article 77 is only applicable in the cases of damages, and the present matter is about specific performance under Article 62 of the CISG, as there is a payment claim that arises in the present matter and a contractual obligation that has not been fulfilled. I see that my time is up. If I may seek an additional extension of 30 seconds.
Yes, there's a question.
A
Yes.
question, first counsel. Do you consider that claimant has been diligent in not informing a respondent after not receiving the first payment on the 3rd of May?
Mr. Arbitrator, to answer that question, the first cyber attack happened on the 5th of January, and it was discovered on the 23rd of January by the claimant organization. At that point, we employed the leading cybersecurity firm in Mediterranean, CyberSec, which assessed the attack to be of minor relevance. The phishing email was sent in March, where the claimant itself had no idea that it is under a phishing attack. And therefore, even if we had informed them about the cyber attack after we discovered it on the 23rd of Jan, it would have made no difference, since all the information we could have given them was that there was a cyber attack and it was neutralized. After the phishing email was sent, and we did come to know in May that our subsystems have been hacked by the cyber attack, we did pass an internal order in the company to inform all our counterparts about the same. However, unfortunately, the respondent could not be informed about that due to the internal problems in the claimant organization. We were under extraordinary circumstances, not just dealing with the cyber attack, but Miss Audie's termination and Miss Pugitron's difficult pregnancy. And therefore, it is our submission that we were reasonable in all the actions that we undertook, if that answers your question. Therefore, to conclude our submission, members of the tribunal, we submit that the claimant is entitled to receive complete payment under Purchase Order 9601, and that the respondent cannot evade this liability by using either Article 80 or Article 77 of the CISG. If I am of no further assistance, I conclude my submission.
Any questions?
Thank you.
Thank you very much. Right.
Mr. Presiding Arbitrator, members of the tribunal, as the opposing counsel consented, as is the theme of this present case, both parties did actions that are not desirable and somewhat led to this loss of $40 million. But we need to look at the bigger picture. Parties conclude contracts where they set out obligations. and that are meant to be reciprocal. Now, claimant violated the reciprocity or disturbed the reciprocity of the contract, where it created additional risk, and now asks respondent to take some additional measures and additional expenses to perform this contract. And that is why the tribunal should rule in respondent's favor.
So just remind us of how you put the obligation to inform in the light of what's been said.
If I may ask to repeat the question, ma'am.
How do you put the duty to inform the other side of the cyber attack?
Mr. Presiding Arbitrator, we derive this duty from interpretation of the Article 80 by the virtue of Article 7.1.
I see. So what's your answer to the question I put to the other side? Both sides, as you concede, could have acted differently, and if they'd done it, we may not be here today. Where should the loss fall then, in the light of those circumstances?
Mr. Presiding Arbitrator, if the tribunal wants to apportion the claim, we submit that to the extent of the mitigatable loss, it should be divided, as per my submission to the Article 77. However, also the tribunal has an option to divide the claim based on Article 80 CASG, and in that case, severity of the act is considered. And we submit that intent is worse than a mistake, and claimant's intent not to inform is worse than respondent's mistake in not noticing the discrepancies. Thank you.
Members of the tribunal, as Sir rebuttal, I have one point to make. The counsel for respondent again highlighted how the non-payment was caused by our actions. However, in the aluminium hydroxide case, it was clearly stated if the other party breaks that chain of causation, then the liability shifts to that party. In the present circumstance, the email contained various red flags. Had the respondent taken reasonable care, it would have realized that our client did not send it. Even after this email, they did try to confirm the contents of the email by calling Miss Audi, and her voicemail clearly stated that in cases of urgent matters, Miss Pugetron needs to be contacted, and no such step was taken either. A significant transaction of $38.4 million is not significant for the counsel for respondent, then I don't know what significant transaction would be. Thank you.
Thank you very much. Right, well, thank you both teams very much for your very helpful submissions. We will retire and consider them. Let you know our result.
Thank
In
you.
due course.
Thank you.
Thank you.
Thank you.
Well, thank you to our esteemed panel and to our brilliant oral advocates from both teams. And we'll all be waiting with bated breath to find out the result this afternoon. So now it's time for us to vacate this room, taking with us everything, please. Don't leave anything here. If you leave something here, it will not be where you left it when you come back. I think we have to invite them to the seafood dinner next year. Welcome to the 21st edition of the Vis East International Commercial Arbitration Moot. We hope you've been enjoying the week and will continue to enjoy the next couple of hours that we spend with you. There are overflow rooms across the hall, and if the audio is not coming through, we need to know. So please send somebody in if there's a problem. I think it's okay, but just to make sure. Now, what we'll do, for those of you who haven't been with us before, which is probably 90% of you, we have a lovely meal, and we intersperse the awards with the meal. So we'll be starting soon with the first course, and we'll have an award. We'll eat some more, drink some more, and have another award, and so on until we reach our finale, which will be the announcement of the prevailing team. So for now, I hope everybody is now seated, and you have your food card in front of you so that they know to give you food. No food card, no food. So careful. We ask that when the awards are being announced, there will be honorable mentions first. And if you get an honorable mention, you're going to be thrilled, and you're going to jump up and down, and you're going to scream and hug each other and all of those things. Please, if you are, whether you're here in this room or in the other rooms, don't move for the honorable mentions. If you are, whether you're here in this room or in the other rooms, don't happened before the honorable mentions. If you are, whether you're here in this room or in the other rooms, don't happen before, don't move. Please, if you are, whether you're here in this room. I love the sound of my own voice. What lawyer doesn't? So, if for the honorable mentions, you'd be happy to wave, stand up, but please don't move from your seats. When we get to the awards of the third runner-up, second runner-up, first runner-up, and of course the top awards, those people will be asked to come to the stage as they're named to receive their awards. So if you're in the other room over there, please run, okay? So with that, enjoy, and you'll hear more from us later.
Thank you all for coming into your seats, whether it was the right table number or not, or bringing your food cards or not. What we are going to do now is start with the awards. What I'm going to first do is introduce Dr. Cesar Pereira, who will be announcing the award or the winners for the David Hunter Best Memo on behalf of Claimant. What we would ask for you guys to do is, who's talking? What we would ask for you guys to do is to applause, but not, do we want them to applause? Wait to the very end to applause. We know you're going to be very excited, but we're already very behind given the number of people that forgot their name cards or their food cards. So let's try and wait to the end to give everyone a round of applause. Thank you. Cesar.
Hello, everyone. So I will be announcing now the David Hunter Award for Best Memorandum for Claimant. And as you just heard, hold your applause. I will read all the honorable mentions first, and at the end, you can applaud. And then I will read the names of the second runner-up, first runner-up, and the winner. In turn, each one is asked to come here to the stage, and there will be a photo opportunity for all three of you after everybody is here on the stage, okay? So, honorable mentions. No applause, right? Singapore Management University, University of Mannheim, University of Ljubljana, La Trobe University, Freie Universität Berlin, Westfälisch Wilhelms-Universität Münster, Charles University, Dalian Maritime University, Shanghai University of Finance and Economics, London School of Economics and Political Science, Goethe University Frankfurt am Main, Johannes Gutenberg Universität Mainz, Shenzhen University Law School, University of Cologne, Loyola University of Chicago School of Law, Yonsei University, Royal University of Law and Economics, National University of Singapore, Symbiosis Law School, Pune, Leibniz University of Hanover, Team 483, University of Miami School of Law, University of Göttingen, Eberhard Karls University Tübingen, Ludwig Maximilians Universität München, WU Vienna, University of Heidelberg, Humboldt Universität zu Berlin, University of Vienna. Now you may applaud. Congratulations. And congratulations to you all, because you were very well behaved. Now, second runner-up, Nalsa University of Law. You may come here on stage, please. Are you here? Oh, you're here. Okay, Chuck, please come on. Congratulations. Now, the first runner-up is the West Bengal National University of Juridical Sciences. And, well, you can stay at that side. Thank you. And the winner is University of Zurich. Zurich, stay in the middle. And, oh. Yeah. Congratulations. Thank you very much. I have to go there too? No, you want to leave the wine?
I have to.
Here.
All right, I'm not done yet, guys, because we're a little bit behind. One thing I did forget to mention, Dr. Cesar Parada is not only one of the various 300 plus arbitrators who have dedicated their time to arbitrate you, but he is also a director on the board of directors for the Vis Eastmoot Foundation. Now I'm here to announce the individual who will be giving the announcements for the Fali Nariman Best Memo on behalf of respondents. Another one of our members, or another one of our directors on the board of directors, Mr. Graham Cottingham. Graham.
Now it falls to me to announce the winners of the Fali Nariman Respondent Award. And before I start, I should say it's especially poignant today to be announcing this award because, unfortunately, Fali Nariman left us just recently, a real great of the arbitration world, and particularly important to Hong Kong, in fact. And so it's an honour to announce these awards, and I'll begin again with the honourable mentions. Please keep your applause until the end. Ateneo de Manila University School of Law, Beijing Normal University, Bucerius Law School, Charles University, Dr. Ram Manohar Lohia National Law University, Lucknow, Freie Universität Berlin, Goethe University, Frankfurt am Main, Gujarat National Law University, Heinrich Heine Universität Düsseldorf, Johannes Gutenberg Universität Mainz, La Trobe University, Ludwig Maximilians Universität München, Nalsar University of Law, National Law University, Delhi, National University of Singapore, NMIMS Kirit P. Mehta School of Law, Peking University School of Transnational Law, Pontifical Catholic University of Sao Paulo, School of Law, City University of Hong Kong, Shenzhen University Law School, South China University of Technology, Symbiosis Law School, Hyderabad, Symbiosis Law School, Pune, the Chinese University of Hong Kong, the West Bengal National University of Juridical Sciences, University of Cologne, University of Göttingen, University of Heidelberg, Westfälische Wilhelms-Universität Münster, and WU Vienna. You may now applaud the honourable mentions. Well done to you all. Now, for the runners-up on this occasion, we have a tie. So the tie for first runner-up is between Albert Ludwigs Universität Freiburg Would you please join us on stage? and the Faculty of Law, the University of Hong Kong. Always like to add a bit of unexpected excitement. And the winner is the University of Zurich.
We have to pretend we love each other. There you go. All y'all are skinny. You're going. Jerry, can you get me? You can cut back the half. Thank you. Thank you. Be careful coming up. Good job, guys.
Thank you so much.
We have a little picture. Come to me. Come closer to me, apparently. Okay, we're good then. Okay. Start this with your life. Oh, I guess actually I should say this. For those of you that won, and Maricel will correct me if I'm wrong, any honorable mention certificates, you can pick them up at the registration table at the end, as well as any certificates that have been needed to be reprinted, etc. But the next award that we will be announcing this afternoon will be the Neil Kaplan Award for Best Oral Advocate. I don't think Mr. Kaplan needs any introduction, as we saw him earlier today. But Neil is a brilliant arbitrator, a wonderful personal friend, also a director of the Vis East Foundation Board of Directors, and the godfather of arbitration for Hong Kong. So Neil, please come up.
Thank you. Good afternoon. During the course of a year, there are many difficult things I have to do, but the most difficult thing I have to do is to try and pronounce everyone's name as correctly as I can, and it's quite a task. So all I want to say is please forgive me if I make a mess of the pronunciation of your name. It's not intentional. So these are the honourable mentions for this award. Usual rules apply. Save all your shouting and screaming to the end. Ellie Mae Dreyer, La Trobe University. Eve Beasley, Nagoya University. Gurnish, Hidayatullah National Law University, Raipur. Helena von, this is a difficult one, Jeliga Leweski, sorry, University of Cologne. Ariane Mehta, OP Jindal Global University. Shruti Harina Danahan, Singapore Management University. Tahil Craven, Monash University. Ben Shippers, University of Cologne. Milena Iraq, University of Vienna. Chin Yurt Maxine Law, Faculty of Law, University of Hong Kong. Sean James, La Trobe University. Ilincha Lesovici, University of Bucharest. Juan Carlo Cabero, Ateneo de Manila University School of Law. Leonie Offenbach, Freie Universität Berlin. Alexander Lukin, Team ID 470. Kasim Rana, University of Wisconsin. Rachael Karina, Universitas Catholic Parahayangan. Jasmana Pusta Ayova, Charles University. Duncan Wei-Ling Lim, Singapore Management University. Giovanni Giusti, University of Zurich. Asif Mamadov, American University of Central Asia. Avia Sanders, Monash University. Gary Sidana, National Law University of Delhi. Usen Tastanbekov, Maksud Nari, I can't do this one, University. Saman Zarif, Fatima Jinnah Women University. Henrik Kroh-Inkel, University of Göttingen. Tamara Galeote, University of Miami School of Law. Patrick Seyfried, University of Heidelberg. Siddhant Pengaria, National Law School of India University. Dhaval Sheth, National Law University of Delhi. Kunal Kilnani, the West Bengal National University of Juridical Sciences. Leo Yang, Arizona State University College of Law. Jiping Yu, Tsinghua University. Aditya Singh, Dr. Ram Manohar Lohia, National Law University of Lucknow. Tin Huang, Peking University. Weiqi Liu, Dalian Maritime University. Sofia Barbosa de Toledo, the Pontifical Catholic University of Sao Paulo. Zorara Almeida, Nalsa University of Law. Di Reng Tan, National University of Singapore. Cecilia Felicitatis Maria, Ludwig Maximilian Universität München. Not quite finished. Shan Maria Prithil Patnuabai, Ateneo de Manila University School of Law. Devyani Joshi, the Hidayatullah National Law University of Raipur. Jacob Riedler, Ludwig Maximilian Universität München. Artyom Ermakov, Team ID 393. Alexandra Santamaria, University of Miami School of Law. Weiran Wang, China EU School of Law. Wing Hei Ansem Lam, Peking University. Niels von Arb, University of Basel. And Lisa Emin Willenberg, University of Heidelberg. So those are the honorable mentions. Sorry. There's a mistake here. I've got the same person as the... Sorry, there's a recount. No. That's what. Okay, that's a mistake. So sorry. Hang on a minute. Sorry. Which one is which? So that's the second runner-up. Okay, that's the first runner-up. Okay, it's okay. Okay. Right, that's sorted. So the first runner-up, and please come up to get your certificate. Second runner-up is Rabia Ibra of the Fatima Jinnah Women University. The first runner-up is Kailash Srinivasan of the O.P. Jindal Global University. Slight hiccup. Hang on a minute. Do that now. Yeah. So the vote counting is still going on, so hang on a minute. Okay. Right. Sorry for that. The winner of the award for the best oral advocate is Zhuo Chen of Peking University.
I'm coming.
over at the head table here that we've just been having a discussion about how well you've all done and how wonderful it is to see so many of you here. But we've also mentioned the fact that there are many people who would love to be here, who would love to have this experience, but just don't have the resources to do it. So some years ago, with that in mind, we decided to have a special award, which was at that point unique to the Vis East, and that is the Spirit of the Moot Award, which is named for our departed colleague, Colin J. Wall, who was a great supporter of the Vis East and a terrific arbitrator and mediator himself. So this award is given to the team which, in the opinion of the students, the teams that have met each other, who've got to know each other, got to know what kind of resources their neighbors have or don't have. And this award is given to the team which has overcome the most obstacles to get here today. And to help present this award, I'd like to invite to the stage Ryan Melicky.
Good afternoon, everyone. My name is Ryan Melsky. I am a faculty coach for Duke University and founder of Flex arbitration practice in Washington, D.C. It's my pleasure to present this award. And the winner of the Spirit of the Moot this year is Ramkhamhaeng University. And along with the certificate, I've brought along a copy of my book, The International Arbitration Rulebook, A Guide to Arbitral Regimes. It's signed by the authors. I brought it all the way from Washington, and it's my pleasure to give this book to the winning team. So congratulations.
Right. Well, I said before that one of the hardest things I have to do in a year is to pronounce all the names of the winning oralists. But the next most difficult thing I've had to do this year with my colleagues is to choose between the two wonderful teams that competed today in the final. Now, we were told very clearly that there has to be a winner and that there can't be a draw. So we do have to choose between two excellent teams. And it hasn't been easy at all. You both did excellent jobs, and we were very impressed with both teams. But at the end of the day, we do have to choose, and the winner this year of the Eric Bergston Award is the National Law University of Jodhpur. Well, now please welcome the runners-up, the very excellent team from Charles University.
We all hope that you have had a really tremendous week here. We know that you've been working really hard for about 6 months, making all kinds of sacrifices. You're here. You've had a great time, I hope. You've learned something. But what happens after this? Well, if you feel that you've got something valuable out of the Vis East, the best thing that you can do is keep in touch. And so with that, I'll introduce the co-chair of the Moot Alumni Association, Naveen Ahuja, about staying in touch.
Good afternoon, everyone. My name is Naveen, and I am the co-president of the MAA. I am both sad and delighted to be standing here today to make some farewell remarks after what has been a highly anticipated and memorable week in Hong Kong. Throughout the journey we have embarked on this week, you have undoubtedly encountered new and exciting experiences that have challenged you, stretched your abilities, and pushed you beyond your comfort zones. Like myself, you too may experience a mix of emotions as you reflect on this week and navigate the transition from this intense competition to what lies ahead. Some of you, maybe it's a bit too soon, but some of you may be feeling a sense of accomplishment and pride in your achievements. Others may be feeling a sense of uncertainty or even sadness as this journey comes to an end. As a former mooter myself, I vividly recall the peculiar feeling after the conclusion of the Viz East Moot. It was odd to suddenly find myself not to constantly have to think about the moot problem or arguments, and to stop dreaming about parts of the problem. It was also a truly enriching experience to witness the energy, the collaboration, and the different legal perspectives and approaches coming together. It was so unique an experience that I had full-on withdrawal symptoms and was insistent that I did not want my journey to end there. And so I joined the MAA. And I thought it was just to hang on for a bit longer, but 10 years later, here I still stand today. Being part of the MAA community not only provides you with a sense of belonging and connection with your fellow alumni, but it also opens doors to various opportunities. And I have witnessed these opportunities coming to fruition. I'll name 3 such concrete opportunities. 1, the MAA organizes a number of conferences and events. They give you a chance to connect and expand your professional circle, and maybe even get you opportunities to coach for the Viz or some other moot, to speak at events, or perhaps to author or co-author articles. Arbitration professionals have so much thought leadership to share and often need assistance preparing for events or putting pen to paper. 2, there is a structured MAA mentorship program which gives you opportunities to seek guidance from experienced professionals and to share your own knowledge with the next generation. 3, the MAA is regularly invited to nominate its members to attend sessions of UNCITRAL working groups in New York and Vienna. Some of our members act as observers on behalf of the MAA and subsequently produce a report that gets published. Imagine witnessing in person how international laws are brainstormed and implemented by the leaders of the field. And these are only some of the examples of the world full of benefits that the MAA gives you. So, to help you navigate these emotions and the Vismut blues, and yes, that is a thing, and to provide you with a sense of continuity and belonging, combined with a range of exciting opportunities and fulfilling experiences, join us, the MAA, the Moot Alumni Association. Stay connected with the Vismut family and build upon experiences and connections you have made. I see my microphone hasn't been switched off, so I must have a minute or two. I'll just mention 2 short points. One is, we, the MAA, welcome both compliments and complaints about any of our events, so please don't hesitate to reach out to us with your feedback. We value your input and strive to continuously improve. 2, hats off to Louise, Sherlyn, and Maricel for making Viz East a great success. To conclude, the MAA is a place where you can channel your post-moot energy and reap the benefits of being part of our world. You never know when a connection made through the MAA could lead to a new opportunity, collaboration, or even lifelong friendship. We hope that you'll become an official part of the MAA. It's free of charge, and it takes 15 seconds to register. I tried it last night. For those of you who are going to Vienna, please do check out our scheduled conference and events, and see you there. Thank you.
It's like everybody's just waiting for me to talk, huh? Or you guys are just trying to figure out if there's any more talking. So, We are at the end of a 1-week journey in Hong Kong, but a 6+ month journey from when that problem was released. As many of you know, although I saw a couple schools posting the wrong number of final schools, this year we had a final number of 144 teams who came to Hong Kong. I mean, we don't deserve the round of applause for that. You guys all deserve the round of applause for that. But that is 33+% more teams than we've had last year, and the most teams that we've had ever. We had 150 teams submit claimants memoranda. So as you can probably figure out, and as you can see from the tightness of this room and the fact that we had a spillover, it was quite the project. Getting all of you guys here, getting all of you guys to the venues, getting all of you guys a place to compete. And it goes without saying that we've got very important people to thank, yours truly included, but I'm not here to thank myself. I am actually here to reiterate all our thanks and support for, number one, our sponsors. As a nonprofit organization, we rely on the financial sponsorship of companies, individuals who give us the money in order to ensure you guys can have this experience. Number two, we have a specific individual who I think is hiding. She's outside trying to figure out your certificates. Maricel, I will not stop until you come in here. Can somebody grab Maricel for me? You guys all know her. She's the one in pink running around. Is she coming? Thank you. Most of you know who Maricel Somerville is. Maricel has been with the Moot, what did we decide, 16 years, give or take? Whatever, it was many, many years, over a decade. But this year she's actually taken on an even larger role. So for those of you who probably got nasty little emails from me because you were asking for her to do everything possible, and she did, we need to give her a very huge round of applause because she's taken on everything. Now, very late in the game, we managed to find another wonderful individual who, unfortunately, because you guys are so difficult to organize, I know you guys are listening to me in front of me, right? Winners, you don't get out of that. Miss Atara Khan, she unfortunately came down with the flu because, again, you guys are very difficult to manage for 7 straight days, but we would like to also welcome her and thank her for her assistance. Round of applause, I'm sure she's watching. And we had a week's worth of wonderful helpers who got yelled at multiple times by me because they were trying to make sure your rooms were okay, you had your water, you guys went to the right place. We have 4 of them here today. Raise your hand, say hi, yell at people who caused you to get yelled at. Thank you very much, kids, girls. I can't call them kids, they are young adults. And finally, last but not least, the person that made this entire competition happen, and it wouldn't be here 21 years later. And if you figure out the timing, apparently it's always around her birthday. So she also gives up her birthday. Poor Michael has to fly all the way out to Hong Kong to make sure she's loved. She's loved by us. But let's give a huge standing ovation to Ms. Louise Barrington, the founder and director of the Vis East Moot.
Thanks to everybody, but mostly thanks to Maricel, who's already been mentioned. She's done a wonderful job. And to my wonderful, amazing, dynamic deputy director, soon to be co-director, Charlene Dunn. Wonderful.
One more thing, for those of you that are still in town, and actually Naveen's gonna correct me if I'm wrong, MAA Moot Bar is still on for tonight. You still get your drink specials. Please do go out, make friends. I can't stop but reiterate how important this MAA is. We've got so many core members in the team. I owe my professional career, the love of my life, and some of my lifelong friends to the VIS and the VIS East. So stay in touch. Come back next year and be an arbitrator, because I don't want to go through the 3 weeks of no sleep again. Thank you.